Disclaimer. REN Technology Services is registered in the BVI. We are a consultancy firm that provides technology services. This video, voiceover, is a true translation of the British Virgin Islands Commission of Inquiry report of the Commissioner, the Right Honourable Sir Gary Hickenbottom. Presented to His Excellency John James Rankin CMG, the Governor of the Virgin Islands, April 4, 2022. None of the text from the report was changed and was transcribed as reported by the Commissioner. The purpose of the translation is to make sure that the general public would have the full opportunity to hear the text as it is presented in the report. REN Technology Services or its owner has no political affiliation or would ever collaborate with any political group to mislead the public. Please notify us if there is an issue with the transcription.
Chapter 4. Elected Public Officials. Continuation. Proposed Reforms. 4.106. In recent years, there have been various expressions of purported political intent to review how elected public officials declare their interests, each of which seems to have run into the sand. In March and September 2018, the previous NDP government announced that it would be reviewing the 2006 Act. I have not seen any evidence that that announcement was followed up. On June 18, 2019, the current Premier Han Andrew Fahey wrote to Ben Merrick, Director Overseas Territories FCDO, that the Register of Interests of Ministers will be made public immediately following further consultation with the Governor. Such a step would, of course, not have applied to all members of the House of Assembly. In any event, the interests of neither elected ministers nor other members of the House are yet public. 4.107. In a cabinet meeting held on November 7, 2019, Governor Jaspert introduced a paper on the integrity in public life policy. Cabinet approved that policy and decided that a review of the bill entitled Integrity in Public Life, 2003 would incorporate a review of the Register of Interests. 4.108. On September 18, 2020, the Deputy Governor instructed the Attorney General's Chambers to prepare a Register of Interests Amendment Bill, which was duly drafted and sent to the Deputy Governor for review on November 4, 2020. On December 3, 2020, the Deputy Governor sent new instructions to the Attorney to prepare a draft bill for the repeal and replacement of the 2006 Act. At the time of hearing evidence on members' interests, 14 to 21 June 2021, what is now the Register of Interests Bill 2021 was still being drafted 195. As of February 10, 2022, when the Attorney General provided an update to the COI, it had still not been finalized or introduced to the House of Assembly. 4.109. If enacted in its current form, this bill would repeal the 2006 Act in its entirety, although it generally replicates the provisions of that Act. For example, it does not change the interests to be declared and, save for some minor amendments, the form of declaration is the same. However, the following aspects of the bill mark proposed changes. It extends the obligation to make a declaration to all those in public life, i.e. not only members of the House of Assembly, but all other public officials and members of statutory boards and the governing body of any other public body, Clause 3 and Schedule 1. 2. It provides for public inspection of the Register of Interests, Clause 5, 3. If enacted and implemented, this would clearly be an important step forward. 3. It allows the Registrar to refer any matter related to integrity to the Integrity Commission for advice, Clause 9. The Integrity Commission is to be established under the Integrity in Public Life Act 2021, to which the Governor assented on February 11, 2022. It is not yet in effect, and the date for when it will come into force has yet to be announced. 4. It imposes a fine of $500 on a person in public life who submits a declaration late, Clause 4, 4, and Schedule 3. Further, it will be a criminal offense for a person in public life to fail a. To file a declaration at all, Clause 4, 5, or b. To notify the Registrar of a change to the declaration within 1 month of that change occurring, Clause 5, 7, or C. To submit a new declaration within 28 days of the registrar serving a notice that an entry in the register is the result of that person making a fraudulent or materially misleading declaration, Clause 6, 5, or D. To comply with a notice from the registrar given for the purpose of examining a declaration and requiring further information or records, Clause 7, 5. With one exception, these offenses would be punishable on summary conviction with a fine the value of which is yet to be indicated, but may be in the thousands of dollars. The exception is the offense under Clause 7, 5. There, summary conviction results in a fine not exceeding $10,000 or imprisonment for a period not exceeding 2 years or both. V. It envisages a different enforcement procedure in relation to members of the House of Assembly. It dispenses with the Register of Interests Committee and removes the ability of the House of Assembly to fine a member or suspend him or her from sitting. Instead, where a member is convicted of an offense under this statute, then, in addition to any other penalty, the court would have the power to suspend that member from sitting and voting in the House of Assembly for such period as the court considers appropriate. The present draft indicates that such suspension should not exceed a period of years, but does not specify the term of such period, Clause 8. Conclusion. 4.110, Registration of Interests, provides a very good example of where elected public officials have deliberately and persistently overridden constitutional controls on their behavior. This has not simply been a case of elected officials failing to comply with their individual obligations. Collectively, they have deliberately, persistently and successfully undermined the system of controls imposed by the Constitution and statute, to the extent that the controls have been effectively spiked for more than 2 decades. It is a measure of their success that, over 20 years after the 1976 Constitution was amended to require declarations of interests to be put into a register, there is still no register. 4.111, There is no excuse. This cannot be placed at the door of anyone else, such as the UK government. The elected officials were well aware of their constitutional and statutory obligations. There is no question of a deficiency in the public service contributing to this state of affairs. The policy in place is clear and set out in the Constitution. Even though the register under the current scheme is not publicly accessible, the position taken by elected officials in successive administrations has been to avoid putting in place and operating a mechanism to give effect to the constitutional imperative for a functioning system to register interests of members of the House of Assembly. It was, rightly, accepted on behalf of the elected ministers, 200 that what has been put in place, such as it is systemically hopeless. No serious attempt has been made to establish a system of compliance and enforcement. Indeed, there has been a consistent, and, in my view on the evidence, a quite deliberate, course of undermining attempts to establish such a system. 4.112, The general approach of the elected officials is reflected by the fact that the Attorney General, acting for the elected ministers in the COI, has reserved her position as to whether to take steps towards prosecuting the former registrar for her, clearly bona fide and, in my view, clearly lawful, attempts to, get a system established as required by the Constitution and the 2006 Act and, 2, encourage individual elected public officials to comply with their constitutional and statutory obligations to make declarations of interests. As I have described, whilst she was registrar, Mrs. Romney Varlak's efforts to fulfill her important governance role were treated with disdain. In all the circumstances, for the former registrar to have even the faintest shadow of possible criminal proceedings hanging over her in her retirement is, with all respect to the Attorney General, unforgivable. 4.113, That the system of registration of interests has never been taken seriously is reflected in the fact that there is currently no consensus as to what needs to be disclosed. That no attempt has been made to clarify the requirements, even in the current Register of Interests Bill, is, in my view, indicative of the lack of any political will to ensure that those in public office are in any way open about their interests and possible conflicts. On the evidence, the concept of conflicts of interest is barely recognized in some quarters, and each elected official currently required to disclose interests has a different view as to what interests should be disclosed and when. 4.114, There is the new bill. Whilst I know that instructions were given to the Attorney General to draft a new Register of Interests Bill at the end of 2020, prior to the calling of this COI, the history of registration of interests in the BVI can give neither the people of the BVI or me any confidence that, but for the work of the COI, a bill with provision for a publicly accessible register would have been progressed. Given the position taken by elected officials prior to the COI doing its work, I regret that I have concluded that, without the eye of the COI being cast upon this area of governance, it would have been unlikely that any new provisions would have been progressed even as far as they have been. 4.115, it is said on behalf of the elected ministers that the bill, bolstered by the Integrity in Public Life Act 202/1201, signals a new beginning for governance. However, I have grave doubts as to the effectiveness of any scheme set up under this measure if enacted in its present form. The oath required of a registrar, which is in the same terms as found in the 2006 Act, would present him or her with practical and legal difficulties in obtaining advice from an integrity commission, assuming one were in place and functioning. There is no sanction for persistent late declaration, nor would the public be easily made aware of such shabby conduct. The bill imposes a freestanding obligation on a person in public life to make a declaration. Yet there does not appear to be any sanction for someone who makes a fraudulent or materially misleading declaration. That only arises if the individual is notified that the registrar is examining their declaration, is asked to provide further information and knowingly or recklessly provides information that is false or materially misleading. Clause 7(5). 4.116. Clearly, more needs to be done to the bill. There is no proper form in which declarations are to be made. There are no regulations as yet prescribing the format of any register. Clause 14. Given the evidence of former and current members of the House of Assembly, the declaration form needs to be revisited and guidance promulgated. Where it is suspected that one of the offenses set out in the bill has been committed, there is a need for clarity as to how the complaint would be progressed. 4.117. However, I have a more fundamental concern about the bill. It imposes on the Registrar of Interests the burden of maintaining the register, Clause 5(1), satisfying himself or herself that its entries are full and accurate, Clause 6(1), and taking steps to obtain further information, Clause 7(1). Those important tasks would not only have to be carried out in relation to elected public officials but, among others, all public officers, i.e. many hundreds or even thousands of people. Without proper resources, it would be impossible for any registrar of interests to carry out his or her statutory duties in a way that could give the BVI public confidence in the scheme and preserve the constitutional independence of the registrar of interests. The obvious, and, in my view, high risk is that, without adequate support, the scheme envisaged by this bill would be nothing but another paper tiger. 4.118. A registration of interest scheme has been a constitutional requirement since 2000. The people of the BVI are entitled to its establishment without further delay. Whilst the progress with the bill, late and tepid as it is to be welcomed, on the evidence I have received, it is impossible to have confidence that there will be the political will to implement and enforce an effective system of registration unless steps are taken to improve its prospects of success. 4.119. Addressing that issue, in respect of the scope of the scheme, there is nothing wrong in principle with a scheme that seeks to capture the declarations of all those in public life, including public officers. However, it is simply unrealistic to replace a system in which the registrar had oversight of declarations for 15 public officials but was constantly frustrated by a lack of cooperation with one in which she is expected to have oversight of declarations for hundreds or thousands of individuals without, so far as I am aware, any proposed increase in resources or enforcement resources. Without proper resourcing, a new scheme that applied across, not just the House of Assembly, but the whole of the public service, is likely to be as ineffective as the current scheme has been over the last 2 decades. 4.120. In my view, the establishment of a new registration scheme must be approached in stages. I shall therefore recommend that a system of registration of interests is established that implements the requirements of the Constitution insofar as it requires the declaration and registration of interests by elected officials, gives clear guidance as to what must be disclosed and when, and has effective provisions, involving sanctions where appropriate, to require compliance. However, the system that is established should not merely satisfy the minimum requirements set by the Constitution, it needs to be effective, which requires a new and frank approach to registration of interests and engenders a new approach to conflicts of interest in the BVI more generally. For example, subject only to any restrictions that are truly necessary, the register should be open to public access, and the scheme should be the subject of independent monitoring and enforcement. 4.121. Only once that system is embedded, and its effectiveness has been properly evaluated, should it be extended to encompass others such as public officers. In the meantime, a properly formulated and costed plan for such an enterprise should be prepared, with a commitment that resources will be made available to ensure that such an ambitious new scheme is efficient and effective. 4.122. Whilst the bill, in my view, has considerable issues which I have outlined, it is a start, and may at least provide a vehicle for the reforms I propose. However, it clearly requires more thought and, indeed, more action. It certainly needs to be pursued with more endeavor than hitherto. Recommendations. 4.123. I deal with overarching recommendations, below 203. However, with regard to the registration of interests, I make the following specific recommendations. Recommendation B2. I recommend that a system of registration of interests is established that implements the requirements of the Constitution insofar as it requires the declaration and registration of interests by elected officials, gives clear guidance as to what must be disclosed and when, and has effective provisions, involving sanctions where appropriate, to require compliance. Subject only to any restrictions that are truly necessary, the register should be open to public access. Recommendation B3. I recommend that, before the introduction of a registration of interests system designed to cover all persons in public life, a properly formulated and costed plan should be produced for the implementation of such a system, and a commitment made to ensure that it is, and will continue to be, funded and resourced so that the system is efficient and effective. Recommendation B4. I recommend that, once the registration of interests system for members of the House of Assembly has been established, evaluated and its extension costed, then consideration should be given to its extension to other public officials on an incremental basis. For example, the first tranche of public officers to be covered could be the most senior officers such as the permanent secretaries, the financial secretary and the cabinet secretary, or those acting in such roles. The second tranche could be members of statutory boards, and so on, until all public officers intended to be included are covered. Recommendation B5. I recommend that Sections 66 and 67 of the Constitution are amended to make clear the circumstances in which a person seeking election to the House of Assembly or a member of that House who, either personally or through a DBA, partnership or company with which he or she is associated, contracts with the BVI government needs to declare such an interest, how such a declaration should be made and the consequences of him or her not doing so. Recommendation B6. I recommend that Sections 66 and 67 of the Constitution are amended to make clear whether, having regard to the purpose of these provisions, the term Government of the Virgin Islands is intended to encompass statutory bodies whether engaged in commercial or non-commercial activity. It is my view that they should include such statutory bodies.